Good afternoon, Elder Justice Lunch and Learn community. It is so wonderful to be back with you after a brief summer break for the month of July. I hope you all are coming back rested and excited to take on new challenges around advocacy and opportunities to learn from each other. So it's exciting to see everyone back. My name is Nicole Howell. I'm the Executive Director for Empowered Aging. I want to remind everyone that we value a really inclusive and yet interactive webinar. So there's some tools that we have available for you. We do offer everything. You're able to connect with us. We encourage you to use the chat to connect with your fellow learners today. I want you to get you started off by go ahead and drop in the chat your name and maybe sort of where you're from and what you do, so we can learn about what part of the elder justice neighborhood you are from. It's also where we'll pull questions from. So as we go through, I'm sure there's gonna be lots of questions and opportunity to give feedback. Feel free to use the chat or the Q&A to drop your questions, and our speakers will answer them at the end of today's webinar. Also want to remind everyone, we are closed captioned and we have ASL available via the Zoom feed. So please take advantage of those resources. And of course, we do send out a recording a few days after the session. So you don't have to furiously take notes. You're able to take advantage of all the resources and opportunities to understand more effectively. So again, use the closed captioning and the ASL interpreters. We are launching our second year, and we will be here on the third Thursday of every month through the end of July of 2022 at the very least. And this year, I think really we're going to dive into some deeper topics that you all raised last year. So be sure to mark your calendar for next month, and we will see you then. Also want to say a deep thanks to our sponsors. First of all, Kaiser Permanente. And of course, California Department of Social Services, who is the provider of all of our ASL interpretation. Also, we're proud partners with California Long-Term Care Ombudsman Association, our new supporters, Archstone's Foundation, and John Muir Health. So today is kicking off a two-part session where we're going to be diving into some legal issues. And so the first thing is, I have noticed as an executive in the nonprofit field and elder justice that I keep hearing the term, and I want to be honest, first thing we're going to learn is, how do you say it? Is it amicus? Is it amicus? What is the right way to say that term? And what is it? And how can we as community advocates use this important legal tool to create systemic change for our clients? And so we've assembled a fabulous panel today of experts in the field who both are either attorneys themselves or who are nonprofit leaders who have leveraged this tool to impact the sort of system and move their issue forward. And so it might seem a little dense and it might seem a little heady, but I want to say today is really about in-depth learning. So I want to appreciate you all being here. And with that, I'm going to turn it over to our newest panelist, Sil Vossler. He's the founder and principal of the Vossler Law Firm, and he is going to lay the foundation for this topic today. So Sil, let me invite you to turn on your camera and your microphone, and I'm happy to turn the baton over to you.
Nicole, thank you so much for the generous introduction. And thank you for putting me on the spot with the pronunciation. To be honest, curiae is a cumbersome word. And so you're going to be hearing me call it amicus brief, because I think that's a lot easier to say. Hi, everybody. I'm Sil. I am the founder and principal of the Vossler Law Firm. I handle elder abuse litigation, predatory lending litigation, and wrongful foreclosure litigation against banks in particular. Before I started my law firm this year, I worked as a senior elder law attorney at Open Door Legal in San Francisco. And before that, I was an assistant attorney general in Washington, D.C. So we're going to be talking about some pretty detailed legal concepts today. But, before we do that, I'd just like to lay a foundation for sort of the groundwork for what an amicus curiae or amicus brief is and where it fits into our advocacy. So briefly, so before we get to case law, which is on the slide, briefly, an amicus brief is something that a non-party to a lawsuit, somebody who is not involved in the lawsuit, will file in a legal case to help the court make the right decision. This conversation is specifically about amicus briefs and how we file them and when you would want to. But before we dive into the specifics, I think it's important for us to put in context a little bit about where these fit generally into our advocacy. This is a tool for us to bring a multidisciplinary and coordinated approach to legal issues. When we file an amicus brief, it is an opportunity for people who aren't legal professionals, people who are government workers, legal service orgs who aren't involved in the case, care providers, to provide important input on legal cases. Now, why is that important? So if we go to the next slide, it's because we have case law. Case law, now this is where it gets a little weedsy, but I'm going to try to keep this as simple and broad strokes as possible. Case law is law that is created by judges rather than by statutes or by regulations. Now, we all know that legislators create bills, which they pass into law, which become statutes. But the courts will interpret those statutes to apply them to the cases that end up in front of them. And for the higher courts, Court of Appeals and Supreme Courts, every time they make a decision on a set of facts that are in front of them, those decisions will be binding on all future cases in lower courts. So every single case that comes afterward that has a similar set of facts, that is applied to the same statutes, the court is going to look at it and say, oh, we already decided this in the past. So we already know what to do. And they're going to apply the same decisions. So if they make a bad decision, it can affect a lot of people. And we recently saw this in California. Just a brief example. And I'm going to keep this as simple as possible. Recently, the California Court of Appeals said that a senior who was defrauded by an insurance company could not hold that insurance company liable. And so a lot of elder advocates got together and said, well, that's going to make it really difficult for seniors to hold insurance companies liable in the future. And a lot of seniors will be hurt from that. And so it was an opportunity for us to reach out to the court, advocates who are not lawyers, social service providers, care providers, to reach out to the court and say, hey, this is a bad decision. So if we go to the next slide. So if we see cases in the higher courts, Supreme Court, Court of Appeals, that have bearing on important issues, what can we do? Well, we as non-parties can file amicus briefs. An amicus brief, or amicus curiae, literally translates to friend of the court. It is a person who is not involved in the case, who assists the court by offering information, expertise, or insight on important issues that are presented by the case. For example, in that insurance case, I believe the Department of Insurance weighed in and told the court, hey, we need to review this decision because it allows insurance companies to essentially do things to seniors that would not be in the senior's best interest, and it makes our jobs harder to hold insurance companies liable. And anybody can file an amicus brief, and the court will have the opportunity to look at the brief and weigh how much they have the decision to say over how much weight to give the brief. And so I'm going to hand it over to Jim to talk about his experience. Jim, go ahead.
Thank you, Sil. My name is Jim Treggiari, and I am the Executive Director at Legal Assistance for Seniors. We are an Oakland-based 501c3 nonprofit that provides legal services, Medicare advocacy, and community education. I've been with the agency about 12 years now, 6 years as a practicing attorney, mainly focused on elder abuse and conservatorship, and then the last 6 years as executive director. And so kind of to give you a broad idea of what I'm going to talk about is making that analysis. Let's say you have been approached by an attorney to file an amicus in support or on an issue. What's the analysis that you as an agency would take to decide whether that's an appropriate step for your agency to take? And so I'm going to walk you through kind of the analysis I do for legal assistance for seniors to understand whether an amicus is appropriate given the circumstances. Yeah, and I also, when we're after the evaluation, we'll kind of talk about the writing and submitting process, and then finally kind of follow up and other steps that might be taken. As the case wraps up, there might, it's not the end of the story. There are more actions that can be taken legislatively. As we know, there's lots of ways to impact policy and legislation. And so I think what I hope you'll come away with is this is a tool. I'd say we use it pretty sparingly, but kind of talk you through when it's appropriate and then what we can do afterwards. So when to consider filing, typically in my experience, and I will say up front that I have not been a lawyer on an appeals case. And so I'm approaching this purely from being a nonprofit provider and being asked by one of the parties on appeal to file an amicus brief. Typically, what they're going to do is approach your nonprofit because of your expertise. So for legal assistance for seniors, we tend to get approached when the issues are regarding elder abuse, conservatorship, any issues revolving older adults and their care. We tend to get approached by attorneys. And one thing that's really nice is if you work in this space for a while is you'll start to see familiar names come up. So actually, Legal Assistance for Seniors was involved and did file an amicus in the case that Sil was discussing earlier. And we know the attorney very well who filed it. And so already that lends, some credibility for us that if I know the attorney, I know they do really good work. The more practice you get in it, it's easier to have confidence. We still do our review. We still look at all the facts. But it's a good starting place if you know the attorney and know they do really good work. And so that attorney is going to let you know why they think it's important for your agency to weigh in on the issue. And really, there are two, if you walk away with nothing else, there are two main things that in terms of analysis that I would recommend. One is understanding, are you an expert on the topic being discussed? Are you truly a party that has the expertise and the authority to weigh in on a case, to give the judge that perspective that Sil was talking about that might not already be on the table, and that carries the weight that it will be read and considered. And two, what I consider is it right for the agency? And what I mean by that is I always want to be careful in considering that this is something that is right for the agency, that it's a public stance that we want to be taking, and that the parties that are involved, that we're aligning in a way that fits the values and the mission of our agency. And what are the consequences for the client? As Sil mentioned in that perfect example, is that there are real concerning consequences in that particular case where if the decision does not go in the way we hope it will, there are going to be a lot of long-term consequences for older adults in the state of California that can lead to some really unsatisfactory outcomes. And so that's really what we're trying to avoid, is to give the judge a preview of, hey, if this goes poorly, or if this goes against, I would say, older adults, that's really going to be detrimental to older adults in California moving forward, and that it wasn't the intent of the legislature when the law was passed. Something I have the luxury of, that some of you may not, and you're going to hear come up several times, is that I work with attorneys, and so my staff, I have 10 attorneys on staff. I have board members who are attorneys, and I think if you have access to attorneys who can help you with editing and drafting and looking over and making kind of decisions about whether filing an amicus is right for your agency is really valuable. And so if you don't have the luxury of a board member who is an attorney, I would say that trying to form those relationships, to find an attorney who might be able to do some review or drafting with you pro bono, because it is for public good. You would, I think when approaching an attorney or a firm and asking for this help, it would be really positioning that if you were coming from, say, my example would be as a nonprofit, that we would love this support. We would really feel more comfortable if we had an attorney reviewing and looking through the case and the law, and helping us get that out there. I think that's something that to a lot of firms would be a comfortable ask, and would be a really nice way for them to give back to the community. So, what are we typically considering when we're approached to file an amicus? Like I said, I think number one is the law that's being appealed. Just because it involves older adult does not mean that the community needs to hear from legal assistance for seniors. And I want to be careful in that, and I'll get into this a little bit later, but that it's very, there have been studies that show that judges really don't only consider a small percentage of the amicus filings that are brought. And so I think, one, making sure that you are an expert in what you're writing about, one, helps the court know that you really are an expert, and that really this is well within your wheelhouse of what you do and what your work is. And two, you just don't want to waste your time. I think, as Leza will talk about a little bit too, these take time, as you can probably already tell, in the review, the consideration, the drafting, the filing. This all takes a lot of time. And I would assume that, like me, a lot of you are incredibly busy. And so taking the time, when I do take the time to write and submit one of these, I want to make sure it's an effective filing, and that I, one, haven't wasted time, and two, I am contributing to a case where I am an authority or an expert. Another question you want to ask yourself is, do you want to be involved in the case? I always like to take a look and ask the attorney who's asking me to file an amicus, who are the other parties that are signing on? Have they been able to get other amicus briefs? Does the other side have any? We're taking a public position, and I want to be confident and comfortable in the position that I'm taking on behalf of my agency. A lot of times I will ask if there's other agencies that might be better positioned to do the advocacy. And so in the examples Scylla and I have been talking about, I also did some brainstorming for other agencies that the attorney may approach who would be good fits to also file amicus briefs because of, again, their expertise, the work they do, and I think the clout with which they speak. And so, trying to brainstorm around those parties who would be effective in that advocacy. Courts vary in their allowance for amicus filing, so understand if it's worth your time. And so that is kind of going back to that point that there have been several studies that show that only a percentage of these cases actually get reviewed, or a percentage of these filings get reviewed by the judge and taken into consideration. So making sure, I would say, from my perspective, use it very sparingly. And the bottom line, again, is, are we really the experts? Are we a group that has insight into how this is going to impact clients that the judge may not be considering by the filings already put forth by the parties? Next slide, please. Okay, so say you've decided to move forward. First, I'm going to say that, there are times when I've decided that LAS is not the right party to submit an amicus brief. And so how do you let the attorney know? And I think there's a couple ways. I think, as we've been talking about, the most common way that I politely decline to file an amicus brief would be saying that LAS is not an expert in the area, that although the case involves older adults, and that is our population and who we work with, that given the substance area or what is at issue, that I did not feel that LAS had the authority or the expertise to speak to the court about the impact it would have on our population. So that's the most common way to decline, I would say, is that you do not feel comfortable that you're the right agency to put that brief in. I also feel like if it's that you're not getting a good sense from the case, or that you're getting some red flags in terms of the position being taken, being contrary to the mission and the values that your agency holds, I have used everything from saying that, my board of directors doesn't want me filing amicus briefs at this time, to saying that I just did not feel comfortable. So I recognize it could be an uncomfortable situation, but I would really say, especially as an executive director, everything that I do, is a reflection upon LAS, and I hold that reputation and that kind of general perception of LAS very, very close, and I take that incredibly seriously. And so if we're going to put anything out publicly, I have to make sure that it is 100% something that I want to back, and feel good about putting out in the public. So when writing it, go back. I'll do a little bit on how to write and submit. Thank you. Generally, effective briefs are concise, speaking directly to an issue and being factual in nature. Remember that you are not the party in the case, and you are probably not, in most cases, the expert in the legal nuance that Sil was talking about, or the case law, or diving into the legal issues at play. You're really there to explain the impact it will have on your clients. The court doesn't want to hear from outside parties as to your analysis of the legal piece of it. This is really impact. Like I mentioned, you may want to have an attorney on your board or outside pro bono review if you are unsure of the position you're taking. I'm so fortunate to have board members who've done this type of work, who, before I file anything, I'll run it by them for a check just to make sure. And it really gives me a lot more confidence that what I'm submitting is appropriate and, is a good filing. The court is considering the authority and the soundness of the arguments. Stick to provable data within your knowledge. Don't speculate. You can lose credibility in the eyes of the court. And so really sticking to an issue you feel confident about, you have a lot of knowledge and understanding, I think is the best bet. And something to keep in mind is you will not be asked to come in front of the court. So this does not make you a party. You will not be deposed. So for some of you, you're wondering, does this drag me into a case? Will I then have to attend court? And that's not how it works. So I'd say in my experience, and I'd be curious to hear from Leza and Sil, the worst that's going to happen in this is that your filing gets ignored. And you're possibly aligned with some people that, you weren't intending to be aligned with. I think is kind of really what you're looking out for. But this is not a vehicle for you all of a sudden to be a party in the case where you'll need an attorney, where you'll need counsel, you're going to get deposed. I haven't seen any of that happen. So just kind of framework wise, it's really the submission and then you kind of wait. Okay, next slide. And so actually, I didn't pay Sil, I promise, but this was the exact example I was talking about. And so in that case, the attorney who was making the appeal came to LAS and asked if we would file an amicus exactly for the reasons that Sil discussed, supporting the motion to review and reverse the ruling about insurance carriers. And then there was also a piece about payment for attorney's fees in elder abuse cases. And LAS did put in an amicus because we knew the attorney, We knew the other parties involved who were filing amicus briefs, who we were closely aligned with. And we felt confident that, our filing was with a group of like-minded experts who were very reputable, who were putting in strong support of a position we needed to take. And so the analysis I did for LAS is, I would, after the agency has been in existence for 45 years, we are an expert in elder abuse. We've handled thousands of these cases in 45 years. And we really could speak to how damaging the ruling would be for older adults. So in this scenario, along with the help of my board member, we were able to put in an amicus brief that I felt really strongly about. That was an appropriate time to do so. Next slide. So following up, so you've submitted your brief. What happens next? Typically, what's going to happen is the attorney will keep you up to date of any decisions made by the court. I think most of the time the parties are really appreciative that you've submitted something and they want to keep you in the loop. Because, I think a lot of times they may come back to you for additional amicus briefs in the future because people tend to have practice areas. And so the attorney that we're working with in that case does a lot of elder abuse civil litigation, does a lot of financial elder abuse cases. And so what that means is that informing that relationship, if any of his cases, go on appeal, he knows and would like to come back to LAS in that relationship and having us file amicus briefs in support of a lot of the work he's doing. If the decision is not favorable, explore other options like bringing forward new legislation to modify or expand the law that you're concerned about. It may be a launching point for advocacy. So I think while the amicus has, the potential to be impactful in its own right, following these cases and understanding the case law, like Sil was mentioning, with the help of the attorney you're working with, it really could be a launching point. If it doesn't go the way you would like it to, it could be something you could bring to a legislator as a starting point and saying, this recently happened within the courts, and, we really need for new legislation to come forward to make sure that it doesn't continue to happen or to correct this, decision that we believe is incorrect in the courts. So, just to give you to wrap it up, typically I would say in terms of volume for LAS, we submit maybe 1 or 2 a year, maybe amicus briefs. And even that, I think 2 a year would be a lot. So in my 6 years as executive director, I've probably submitted 4 or 5 total, although that number seems to be going up. So just to give you a sense of, this isn't work I'm doing every week or even every month. These are really when these cases align, fairly infrequently, but like I said, maybe a couple times a year. Okay, and I think conclusion. So, if you take anything away, that this really is a valuable tool for advocacy, but it is very specific. And so it's really good to have. I don't think this will be a tool for your agency, like I said, every week or something that you'll be doing very regularly. But having this basic understanding of what the tool is, if the opportunity does arise, does give you the knowledge and the foundation to know, okay, here's the analysis we can go through. Is it appropriate? Make sure, and the bottom line is just make sure you're understanding the case and what you're being asked to advocate for. And don't be afraid to ask for help. A lot of these cases are incredibly complicated, and you're going to be asked to weigh in typically on some specific issues. And so that's, again, another opportunity to pair with pro bono counsel, maybe, someone who can help walk you through the case and really what it means for your agency to be involved. And again, this is one of many ways to create law and policy changes. And definitely, while it's valuable, consider the other tools available in deciding how to proceed. So I think that is it for my slides, and I'm going to pass it over to Leza.
Thank you, Jim. So I want to thank Nicole and Empowered Aging, and congratulations on your name change since we were away during that process. Congratulations, excited. Empowered Aging does fit this organization for sure. So yes, I'm Leza Coleman. I'm the executive director for the California Long-Term Care Ombudsman Association. The CalCOA represents the 35 local long-term care ombudsman programs. We are kind of an independent voice. I like to think of myself as being the ombudsman for the local ombudsman. And, you know, I was not hired as the executive director for CalCOA because I knew anything about the process of case law or how the process for creating or amending regulations. I was hired because I had been a field ombudsman, because I knew what kept ombudsmen up at night. I knew, having worked in the field running a large assisted living facility, I knew what the consumers were concerned about and what the staff were frustrated about. And so that's what kind of powered why I wanted to be involved in CalCOA and learning how could CalCOA as an organization that's made up of the most amazing advocates. I lovingly refer to them as my ninjas, because they are fierce and they are smart and they get the job done. And I saw with CalCOA that these experts, that their voices weren't being heard often enough at the table where legislation was being offered, where case law was being determined. And so that's how I became involved in when CalCOA was asked to sign our very first Americus brief. And I got to tell you, I don't even call it that. I call it Friends of the Court. It's a letter as a friend of the court. And I fully embrace that, because as Jim said, when you're participating in this letter writing, you're not being asked to write law or to offer your opinion on the law. You're being asked to put forward what the impact is on your clients, what the outcomes could be, what your experience doing the work tells you. So I guess move to the first slide. I like to encourage our advocates to get into this field, because I know many of them, having talked with many program coordinators, they feel very uncomfortable with this idea of weighing in on the process of case law or weighing in on creation or amending regulations, because we are very comfortable. Ombudsmen, many advocates, we are very comfortable with the self-advocacy. We can speak up for ourselves. We understand the individual advocacy. I'm working and speaking on behalf of one particular person. But that systemic advocacy, that broader opportunity to weigh in on issues, is something that many advocates just shy away from. And so I think I'm included on this panel, not because I can speak to the technicality of them, but because I can say that we're missing out on an opportunity to leverage and capitalize on our expertise as the people that are working with the clients that will be either positively or negatively impacted based on this, based on the outcome. So that's why I'm here. I want to repeat some of the things that Jim said. Writing one of these letters is not going to get you dragged into court. You're not going to have to produce a work product. You will not be asked to divulge confidential information about your clients. Kind of like when I was an ombudsman, we would say to family members, if that they were free to, and we would encourage, a family member could send a letter to a doctor about what they saw happening. Not because they thought the doctor was going to talk to them, because they're not the responsible party and the doctor has HIPAA rules, but you're providing the doctor with information, critical information that they may not know or obtain through a 20-minute meeting with that older adult. And so in some ways, this letter writing is like that. You're you're stepping up to say, I have knowledge and I think it's important that you hear from us. So no, you won't get dragged into court. It doesn't cost you anything other than your time. And it doesn't happen that often. So there's that. I think the other thing I wanted to point out was how we do it for CalCOA. We kind of created some structure. As the executive director, I have certain authority for topics that I have the established authority to say, yes, this is something that CalCOA could weigh in on. This falls in our wheelhouse, I think was the word Jim used. If a request comes in to CalCOA and I'm not as comfortable with it, maybe it is something about an older adult, like in the case that Sil and Jim are talking about. It is an older adult. It is an older adult that may have some cognitive impairment, but this older adult doesn't live in a long-term care facility. So I need to cover myself. I need to find out, are we really the experts for this? And so I turn to the board for that kind of support. So I would encourage, if you're an executive director of a nonprofit and you're like, I don't know, spend a little bit of time and craft with your board. What do you have authority on as far as subject matter? Then let's see, what else? I think we'll go to the next line, please. So that picture, I hope Nicole will recognize that picture. It's a little faded, but it's the hallway at the Congressional House of Representatives. It's the hallway of Rayburn House. And Nicole and I and some other ombudsman advocates had an opportunity to go to Washington, D.C. and to speak with elected officials. And I know that speaking before the court is not the same thing as elected officials, but I like this picture because that was a Wednesday morning at about 10 a.m. And you'll see there's nobody there. So who are our elected officials hearing from if we, the experts, don't weigh in? And I think that's why I'm on today's panel. Test the waters. Check to see who else may have already signed on the letter. It may bolster your confidence if you see trusted professionals, people that you have a good working relationship with. But I don't want us to miss out on an opportunity. I know there are rules and laws that have gone into effect that have made our jobs harder. And if we could have rolled back the clock and put our 2 cents in, maybe the court would have understood something a little differently, and maybe the outcomes would have been better. So that's mine. Just jump in. The water's good. So, thanks. I'm going to send this back to Nicole.
Excellent. Thank you to our 3 speakers. And I also should add that each of them are members of the steering committee for the California Elder Justice Coalition. So all these folks are actively considering these possibilities and trying to find new ways to advocate for older adults across California on a continual basis. So question inappropriate, add everything, we want to get to it. So our first question, and I would like to direct this to Jim, which is there a cost associated with filing an amicus brief?
That's a good question. I think it's the courts, and they're always looking to sustain themselves. So I'm guessing maybe Sil knows better actually, but I think that there is. But it's always been covered by the attorney that, we're filing the amicus with. I think the interesting question would be if you, I think bigger agencies like the ACLU or, who have much higher capacity maybe are getting involved in cases and filing these briefs, maybe even outside of counsel. So that's a time when filing fees may come up. But I know for LAS, I've always done it attached to a party, and they've covered any fees never come up. So they've always covered those fees. Yeah, but that's a really good question.
And I think if we extrapolate, think bigger than that, in terms of not just like the actual having to write a check, but how much of your staff time are you really dedicating to each brief? So in terms of like the cost that the organization's absorbing.
Yeah, I mean, I think in the average case, if it's fairly complex and I'm involving the board with writing, I mean, I think I would say that unless it's incredibly straightforward, we're probably looking at about 5 to 10 hours of work. Mm-hmm. And maybe that's just me being, I tend to really want to be comfortable with, fully understand, know what I'm putting into the court. So I want to be very cautious and careful. So it could be less if it's an issue that, I know very well and it's very straightforward. I don't think it would take that much time, but, I would say in average, I spend maybe like 5 to 10. And I'm going to take 2 seconds just to really echo what Leza said, in that, judges are people. So, I think until I was part of the legal system, I thought judges were incredibly scary and it's this very formal thing. And in court is scary for a variety of reasons. Even I've been an attorney for a while and I still find court scary. But they are human and they do want to hear and know who's being impacted. That is important to judges. And so I was fortunate enough to be part of another panel that worked on who gets to become judges in Alameda County, and we make recommendations. And what it was an incredible opportunity to learn is that these people are so passionate and caring about their communities and the impact that they're having in their community. And people become, judging is a very incredibly hard and time-consuming job. And people do that because they really, really deeply care about their community. And so just to take away some of that kind of like mystified status, like, hearing from community members in a non-advocacy role in this case, is incredibly important, because if you come in as an expert and you're saying, I believe this is the impact and this is what's going to happen, and they're not hearing it from a party who has a very particular slant or take on this case, who has a client, that can be incredibly impactful. So not that they're not in a position of power, they absolutely are, but it's also fair to remember that they're human beings and they care and they want to hear, what they're doing is going to matter.
Yeah. I hear all of you, especially you and Leza, echoing the idea of, if we only allow the voices that are already in the room to be there, we will continue to have the system that we have. That we as sort of advocates and community-based organizations have to sometimes be brave to change the conversation, to allow more voices, to open the door a little bit up for more possibilities. And I think that's the message I hear here. And I think it applies to a lot of areas.
Nicole, I'd really like to jump in on that too. Oh shoot, I'm going to lose my train of thought. I think it's the unintended consequences that our letters can help address. Because the lawyers for the client, they see it and they want to protect the client, and maybe, the opposing side, it's all about this individual situation, but we're seeing what the ramifications are going to be. And I think we really don't want to miss out on that, because the courts are just focused. They can be so focused on the litigants and their arguments that they miss the impact for the broader community. And that's I think, a very valid reason why we should get involved. And I would echo that Jim said earlier about the amount of time. And I think it does realistically take 5 to 10 hours. Mm-hmm. And yet, how many hundreds of hours might we spend if it goes and makes our clients' lives more difficult, more challenging? So little now versus a lot later.
Mm-hmm. And just to your point, Nicole, I think I have been in my time as executive director, and I'm sure a lot of you who are in leadership positions feel the same. I'm continually reminded of how much we need to interject the voice of older adults into these conversations. And I have been in so many rooms with legislators and directors of agencies and people who are very well-meaning and want to do the right thing. And just because, they haven't heard that perspective of advocating for and supporting older adults and the very specific needs that our clients need, that gets lost. And it's not intentional. It's not because they don't want to run an amazing program. It's because nobody stepped forward in time and said, hey, you're doing great stuff, but let me make these 3 suggestions or 3 ways that, this is really going to be better for older adults. And I would say more times than not, I regret not speaking up in those situations than just assuming that person, oh yeah, that person gets it. They're good at their job. They get it. I don't need to speak up.
Mm-hmm. Yeah. Our next question, we're going to go to Sil for our next question. Before I do, Jim, I want to ask you one follow-up to that, which I think as nonprofit leaders, we often hear we are not allowed to advocate for any real issue. We're a nonprofit. We risk losing our nonprofit status. We have to just stay in our lane, nose to the grindstone, and do the direct services. So what do you say to the response of, well, I'm not allowed to do that? How have you addressed that for your organization to make sure you're staying safe and protecting things in the future, but still addressing the issue?
Yeah, that's a great question. And I think the first thing to do and what I did as I got more kind of active was understanding where the lines are. So, while advocacy is something that needs to be carefully monitored, you can still do it, but we can educate legislators and judges, and we can educate all we want. And that does not go towards our 501c3 status. Mm-hmm. That being said, I still have implemented where I track the time I spend in Sacramento on policy work, on advocacy, and knowing those threshold numbers, and knowing kind of again, another great place where I think you can get some pro bono guidance from people who do nonprofit law to understand it. But I think, again, like Leza said, I feel so much better having done that work, understood where I lay and tracking that versus saying, like, putting my hands up and saying, like, we're direct services. I don't do advocacy. I don't do education. So just doing that homework and really making sure, because it is an incredible opportunity to make real impact. And I'd say a lot of it qualifies under education. I'll say for myself, I feel like a lot of what I'm doing is educating and not necessarily advocating for a specific piece of legislation or a specific policy. I'm educating as to the needs of older adults.
Mm-hmm. Yeah, I like it. Thank you. So Sil, I want to bring you back into the conversation. We've got a lot of people on this call who are experts in a particular field, medicine, healthcare, long-term care, but they are not necessarily an attorney. So do they have to wait for an attorney to come to them to ask if they'll file an amicus brief, or can they do so proactively on cases they see coming up?
I would recommend that they build relationships with attorneys. And I think it's something I think about a lot lately, the need to build multidisciplinary groups of professionals who have expertise in all kinds of different areas to collectively tackle the problems facing older adults. I think about this in the context of my own cases, where somebody will come to me, a senior will have been defrauded using a particular scam, or will have lost a lot of money in a particular predatory loan. Mm-hmm. And Leza talked about this earlier, how lawyers are generally focused on the parties to the case. And so I'll see that this really messed up thing happened to one person, but it's only through talking to experts in the field, through talking to the district attorneys and the police and APS workers and social service providers and care providers that I can figure out that, oh my God, this is not just happening to one person. This is happening to a lot of people. And so, I've been making a lot of efforts on my own to contact and develop relationships with care providers, and I really encourage the social service and care providers to do the same and establish relationships with attorneys so that they can know what's going through the pipeline. If there are important issues that are being determined by the courts, they may want to talk to their attorney contact and say, "Hey, is this something we'd want to speak up about, to let the courts know the context of this decision and how it will affect people outside of the people who are involved in the case."
So if we develop these relationships with attorneys and we're sort of feeling like we've got some trusted partners, and a case comes up and they approach me and say, "Hey, Nicole, look at this case. We think empowered aging should sign on." What questions do I have the right to ask the attorney? Because here's the thing, when I get a letter from an attorney, that just scares me right off the bat. I'm just like, oh, somebody, if there's a JD behind their name, it's a little daunting. And so I feel like sometimes I become maybe my lesser self and sort of don't ask all the questions I would want to. And so what can I ask them without being disrespectful? And add on to that.
Ask them whatever you want. It's your organization that's on the line. And, if you are taking positions that you don't endorse fully, that's not going to be a good situation. And so, it's your reputation on the line. You don't want to be taking positions with alongside organizations that don't share your goals or interest or expertise. And so I would encourage you to ask as many questions as you can until you're comfortable with the position you're taking. And if that means grilling them, go ahead.
Mm-hmm. So there's a question I'm going to throw out, and it comes from the incredibly knowledgeable Glenn Fishman at the Elder Abuse Program in San Francisco. And he is much smarter than me. So I'm going to read his question directly and then pick it up if you'd like to answer it. So is there an issue with an organization you query to support an amicus brief ask court to depublish the ruling instead of asking for it to be reheard? So I think that maybe you have to speak attorney to understand that in its entirety. So Jim or Sil, can you maybe inquire or dig into that question a little bit?
Jim, what are your thoughts?
Oh, you beat me to it. First off, hi, Glenn. I think I will say that in my experience that hasn't come up.
Excuse me, the interpreter missed that question. Would you mind please repeating the question?
I'm so sorry. I just deleted it so I can't see it. But basically it's asking, can you ask the court to depublish instead of reheard? Am I understanding that correctly, gentlemen?
I think, yeah. So you can ask the court to depublish. I don't know that I feel comfortable giving an answer to that. So if you have any experience, I think it's a very valid question.
Maybe explain the question, Jim, because I think those of us who don't speak courts don't know what that means.
And so basically what you're asking the court to do in that scenario, and I'm having nightmares of my third year of law school right now. So Scylla, please, John, I'm being exposed as a lawyer here. You're asking the court that published decision, basically when a decision gets published, it's the court putting forward that this is of a level of importance and guidance that it is to be followed. It's the law of the land. It's kind of an extra step in terms of it being a published decision, meaning that other courts should follow. And so depublishing would be asking a higher court to basically remove that publishing from that case in saying that it is not, it should not be followed. It's not good law. So you're basically making that same argument that the precedent being taken, the position being taken by the judge in that court is incorrect or flawed for some reason, and that you're asking the court to depublish it in terms of it being what's called precedent, meaning that it should be followed by the other courts. How did I do so? I think I get a B-, and is that a B- answer?
Yeah, I think you did good. You can ask a court to depublish an opinion to make it so that that opinion can't be used in the future in future cases. I've also never seen it, and so I can't really comment on the difficulties with asking a court to depublish an opinion, or even what the standard is there. So I can look into it, Glenn. Also, hi, Glenn. And I get back to you on that.
Great. So we have one last question, and we have only a few minutes, but we've talked about this primarily in relation to sort of state courts. Is this an issue? Is it something that we also should be on the lookout at sort of big federal cases? And maybe if Jim or Sil, if you can pick that up, sort of, should we only be looking at state issues? Should we be on the lookout for federal issues? Does this apply in both scenarios, or is there a difference?
I can jump in here. I think we're more likely to be heard on state cases. These big federal cases ending up before the Supreme Court or the Court of Appeals. So many organizations in so many states are going to be reaching out, and these are typically very high-profile cases. Whereas the cases that are going on in state courts, most of these cases, nobody's filing any amicus briefs, nobody's weighing in, and they kind of fly under the radar a lot of the time. And so, Leza talked about this before, how, sometimes a decision is made and all of a sudden there's bad law and it just happened. And now all of us as advocates have a more difficult job because our clients are being hurt by the laws that are in effect. And I think that's certainly going on in state courts. And I think we have a greater opportunity to actually be heard there. So, Jim, what are your thoughts on that?
I would totally agree. I think there's just like a practicality issue in terms of in these big federal cases that, who am I? I just think there's just a very practical barrier to being heard in that level. Whereas at the state court level, like Sil said, I think we can have a real persuasive impact on a judge's thinking, a judge's thought process, because there's just not that many filings happening. And, I think especially if they're carefully done, they can be really impactful.
Yeah. Well, thank you to all of our panelists. Also, a thank you to our ASL interpreters today. We appreciate all of your support. I want to remind everyone, Christy's going to drop in a chat in a minute the link for our September session, which is going to continue this discussion. It is we're going to be joined by Mark Redmond, who is an elder abuse attorney in private practice, and we are going to talk about how we, as community-based organizations, can work with or refer ethically to attorneys in private practice and know our clients are being cared for. So I look forward to seeing you all back here next month. Please share this information with your colleagues and your friends. And again, you'll see the recording in a few days. So with that, I wish everyone an enjoyable remainder of the summer, and we will see you back here in September.